Hi class, so we're already in chapter 8, or a sale made by one who is not the owner of the subject matter, or one who has voidable title to the subject matter. So what are the consequences in this situation? So Article 1459 requires the vendor to have a right to transfer the ownership of the subject matter at the time of delivery. So when the seller at this point still has no right to transfer ownership, then the rule is that provided in Article 1505, wherein uh, since the seller has no right to transfer title or ownership, then the buyer will actually not acquire any better title to the goods than what the seller had. And this is pursuant to the legal maxim of nemo dat quod non habet. You cannot sell or part with what you do not own. So the consequence when the seller cannot transfer ownership at the time of delivery is that the vendor or seller is liable for breach of warranty against eviction if it is applicable. Okay, and the buyer will acquire no right or no better title to the goods than what the seller had. So question, will the contract of sale become void? So this has already been previously answered in our discussion sa previous chapters. Ha? So uh, just review Null versus Court of Appeals and Cavite Development Bank versus Spouses Cyrus Lim. Okay, and also remember this rule. If there is any, uh, if the contract of sale has not been rescinded and there has been previous delivery of the property to the buyer, then what happens when the seller subsequently acquires title to the property is that there is automatic transmission of that title to the buyer, right? It will cure the lack of right to transfer at the time of delivery of the property by the said seller. So by operation of law, guys, this is in accordance with Article 1434. And this was illustrated in the case of Quijada versus Court of Appeals. How about in a sale of a co-owned property? On the rules on co-ownership, guys, co-owner has complete ownership over his share. So a sale made of the share of that co-owner is a valid contract of sale. Okay, but if one co-owner will sell the entire property and there was no consent from the other co-owners, then the rule is that the sale is void as to the sale of the whole property, but it is valid as to the share of the co-owner. So the remedy here will be that of partition or also redemption. Okay, but there is an exception to the rule. So the sale can be entirely voided, including the sale of the share, when the subject matter is indivisible and cannot be subject to partial annulment. So di man siya ma-partition, guys. So that's why the sale will become void. And when a co-owner, on the other hand, will sell a specific portion of the co-owned property before actual partition, before designation of the respective shares of the other co-owners, then the sale is void as to the sale of the specific property, but still valid as to the share of the co-owner seller. Okay, but there's also an exception to this rule. The sale is entirely valid when the co-owners gave their consent to the sale of the specific portion, since there is considered to be a partial or de facto partition already. So remember that partition can be expressly made through an instrument, or it can be implied from the acts of the parties, such as when they already had the co-owned property surveyed and they subdivided it and they occupied their respective portions. There is de facto partition already. Iapas lang ang titles to reflect the state of partition between the former co-owners. So let's study further these two important articles, Article 1505 and Article 1506. In Article 1505, guys, the seller here is not the owner, okay? And it is not being sold under authority or with consent of the owner. So the rule, therefore, is that the buyer will acquire no better title to the goods than what the seller had. On the other hand, in Article 1506, the seller here has a voidable title. And at the time of the sale, that title has not yet been voided or annulled. So in this scenario, the buyer acquires a good title to the goods, provided that the buyer is in good faith and for value and had no notice at all of the seller's defect of title. So Article 1506 will authorize or allow the buyer to acquire ownership from that seller with voidable title. So the rule in Article 1505 admits of several exceptions. So foremost of which is when the owner's own conduct will preclude him from denying that the seller was given in fact authority to sell. When the contrary is provided in recording laws. When the sale is made by court order. When the sale is made in a merchant store. When the seller at the time of delivery had at least voidable title to the thing that was delivered. And in case of movables, guys, we have Article 559, wherein acquisition of possession in good faith of a movable under a claim of ownership. And when the real owner of the property has not lost or has not been unlawfully deprived of that movable. And there is also the special rights of an unpaid seller of goods to resell the articles under 1526 and 1533 of the Civil Code. So they are made exceptions to the rule that the buyer will acquire no better right than what the seller had. Because in this case, the buyer can indeed acquire better title, opposite siya. So in the first exception, the justification for that is estopel. The owner is stopped from denying that there was authority to sell given to that seller. And remember 1434 in the Quijada case, if the seller will later acquire title to the thing sold, then by operation of law, it can be passed to that to the buyer. Okay, provided that the contract of sale has not been rescinded or annulled. And there's also a rule in Article 1435 that if a person represents himself to another in order to effect a sale or alienation of a thing, then such representative or agent or attorney in fact cannot subsequently set up his own title against the buyer or grantee. So dito siya ka-assert na siya na ang seller as against that buyer or grantee. And in fact, compelled gay siya na mo transmit sa ownership kay na-acquire naman niya ang title to the thing. So second exception is when recording laws provide otherwise. So in the property registration decree, the innocent purchaser for value can rely on the face of the torrent's title, provided that there are no annotations or inscriptions therein indicating that there's any defect or encumbrance on the property. Then we apply the mirror principle, and the innocent purchaser for value can acquire better right than what the seller had kung naay defects ang title sa seller. Okay, and of course, if the court will order the sale of a thing in an execution sale to satisfy a judgment, then that sale is considered as valid, even if the owner or even the sheriff is not even if the court or the sheriff are not the owners of the property being auctioned. So that's judicial power to you. Another exception when the buyer can acquire better title is when the sale took place or was consummated in merchant stores, fairs, and public markets. So how do we distinguish this Article 1506 to the rule in Article 559, wherein any person who has lost or has been unlawfully deprived of their property can recover it from whoever is the holder? So I assign a case for this, which is the Aznar versus Yaptiangco case. So in this case, guys, very gullible kayo ning sila ang son sa seller. Okay, si son man ang naglihok ani sa transaction. So Teodoro Santos is the owner of a car, a Ford Fairlane 500, and he put up an advertisement to sell his car. So a certain L. De Dios responded to the ad, and he proceeded to the residence or office of this Teodoro Santos. Okay, but Teodoro was not around, so the prospective buyer was able to talk with Teodoro's son, Irineo. So De Dios here represented that his uncle, Vicente Marella, wanted to buy the car for 14,700 pesos. So, ni-report si Irineo sa iyong father nga there was an interested buyer, and the father, the owner, instructed Irineo to proceed to the residence of the would-be buyer, si Vicente Marella, in Sampaloc, Manila. So Irineo, obedient son that he is, he went to the house of Vicente Marella. He talked to Vicente, and Vicente indeed offered to purchase the car for 14,700. Condition lang ni Vicente is that he will only pay if the car is already registered in his name. So what the Santos family did was that Irineo, together with De Dios, went to the office of the lawyer attorney Jose Padolina, and they executed a deed of sale with with the assistance of attorney Padolina. So check na deed of sale. Second, they went to the motor vehicles office and they registered this sale. So the registration of the car was transferred to Vicente Marella. So Teodoro instructed Irineo na to keep those deed of sale and the registration papers and not give them to Vicente until he fully paid for the car. So Irineo, together with De Dios, went to the residence of Vicente to collect payment. But si Vicente, he said that he was short of money and they needed to collect the money in the house of his sister, also in Manila. And he was able to convince Irineo to go with the Diyos to the house of alleged house of Vicente's sister. But before leaving to collect the payment from the sister, nihangyo si Vicente na, can you leave those deed of sale and registration papers with me because I want my lawyer to check them out. So trusting kayo si Ireneo, despite the instructions of his father na do not surrender the deed of sale. I am your father, listen to me. Wala man ipatuo si Ireneo. So he trusted those papers with Vicente Marella, and they proceeded to the house of Vicente's sister. Pag-abot nila sa balay, dito, De Jos and Ireneo went inside the house. However, they had a third companion na unknown to Ireneo, and he was left with the car. Nabilin siya sa sakyanan sa Ford Fairlane. So when they went inside the house, De Jos told Ireneo to just wait, okay, and he'll come back. But De Jos never came back. And when Ireneo went outside to look for them, he found the car already gone. He could not find De Jos nor the companion that went with them to the house of Vicente's sister. So he went back to the house and he asked, asa man si De Jos? Only to be told that there was no person who resided in that house with that name. So, next move ni Ireneo, nag-panic mode na ni siya. Patay ko anis kong papalit na kumuli isa. So, he went to the house of Vicente Marella. And alas, the house was already closed up. Closed down. The house was already locked up. So, Vicente had already left. Ni-abscond na si Vicente. So, that same day, no day nawa si Vicente kay gibaligyan na niya sa lain. The car was sold to Jose Aznar for 15,000 pesos. So, Ireneo and Teodoro reported the incident to the police. And they sought the help of the police, and the police took the car from Aznar. So moto si Aznar, he filed a suit for replevin to recover the car. But the court ruled in favor of Teodoro Santos because the court applied Article 559. From the factual incidents of the case, the court found that there was unlawful deprivation. But on appeal, Aznar contended that Article 559 should not be applied. Instead, it should be Article 1506. So to Aznar, his position is that at the very least, si Vicente Marella had voidable title to the goods. Okay, since voidable man yung title, at the time of Aznar's purchase, he actually transmitted ownership to Aznar daw. So the question here is, what is applicable? Is it Article 559 or Article 1506? Was there unlawful deprivation? Or did Vicente Marella acquire voidable title to the car? Okay, if you think about it, si Aznar, ipakitaan siya o deed of sale. Pinaka-execute man siya ng deed of sale, di ba? Ipakita siya o registration. It was named already after Vicente Marella. And then Vicente Marella delivered the car to Aznar. So check na ang all boxes to consummate the sale on top. So can there be unlawful deprivation on the part of Teodoro Santos? So the court ruled here that it is Article 559 which is applicable to the case at bar. Because this article provides that if the owner has lost a thing or has been unlawfully deprived of it, he has the right to recover it not only from the finder, thief, or robber, but also from third persons who may have acquired it in good faith from such finder, robber, or thief. So the only exceptions to Article 559 is when the owner has lost the thing or has been the art not not exceptions to 559. The said Article 559, establishes two exceptions to the general rule of irrevocability of title, and that is when there was loss or there was unlawful deprivation. So in these cases, the possessor, even if in good faith, even if holder for value, cannot retain the thing as against the owner. And the owner here can recover the thing without paying any indemnity. So the only exception when the owner would need to pay indemnity is when the thing was acquired by the possessor in a public sale. But if it's not acquired in a public sale, then no indemnity at all will need to be paid by the owner, the real owner. On the other hand, Article 1506 provides nakatod, kung kay voidable title, which has not yet been voided at the time of the sale, then the buyer acquires good title to the goods. However, this is not applicable in the case of Aznar because for Article 1506 to be applicable, it is essential that the seller should have voidable title at least. And in this case, Vicente had no title at all. There was no title acquired by Vicente because there was no delivery of the car to him. Wala guys, why delivery? Kay di man siya nakasakay ato no. What if nisakay to si Vicente ato? Huh? Yan siya nabilin sa car. Well, nagpabilin sila naa sa sod si De Dios ug si Ireneo. Would the case have been resolved otherwise? Okay, in the facts of this case, Manggod, there was no showing that Ireneo voluntarily surrendered the key to the car to Vicente. So take note na ang car gibilin ni Ireneo to that unknown companion. So masin gi budol-budol ni si Ireneo kay gibilin gid niya ang Yahweh sa sakyanan no. So in this case, there was no delivery, therefore no title was transmitted to Vicente, and therefore Vicente could not transmit any title to Aznar. Right, so take note of this exceptions. Okay, and I also assigned the case of Edca Publishing versus Santos. So another Santos, guys. This time, ang Santos ani kay kuha na siya na ang buyer of the goods which is being disputed in the case. So there's this Professor Jose Cruz, Dean of De La Salle College, who placed an order with Edca Publishing for 406 books. So Edca delivered the books as ordered, and Professor Cruz paid with a personal check. However, this Professor Cruz sold 120 of the books to Leonor Santos, who owned the Santos bookstore. And Cruz showed to Santos the invoices that were shown to him by Professor Cruz, who was selling the books at a discounted price kaya he needed money man. Cruz made another order with Edca, but this time Edca became suspicious because the order was placed too soon, even before the check that was paid for the first order has not yet been cleared by the bank. So muna, dili na nagdapit nag-inquire si Edca about the creds of Professor Cruz. They called the De La Salle College and they also called the bank. So De La Salle College denied having any employee in the name of Professor Jose Cruz. And the bank from which the check was drawn informed Edca that there was no more account in the name of Jose Cruz. So Edca went to the police, they set up an entrapment, and they were able to arrest uh, Professor Cruz, whose real name is Tomas de la Peña. So Tomas later revealed that he sold 120 of the books to Santos bookstore. So that same day, na-entrap si Santos. So that same day, Edca with the assistance of the police, ni-raid sila sa Santos bookstore. And they took back the 120 books, and they threatened Santos with prosecution for buying stolen property. So Santos sued for recovery of the books after the demand for their return was rejected by Edca. So Edca here argued that it has the right to recover the books because it was unlawfully deprived of the books, since Cruz was an impostor, and that impostor acquired no title to the goods that could be transmitted to uh, Leonor Santos. Edca also reasoned that since the payment for the books was not made because the check bounced, then there was failure of consideration, which nullified the contract between Edca and Cruz. So question, does Edca Publishing have the right to recover the books? So was there unlawful deprivation in this case, guys? What do you think? So the court said no. The general rule is that ownership shall pass from the vendor to the vendee upon actual or constructive delivery of the thing sold, even if the purchase price has not yet been paid. So non-payment of the price only creates a right to demand payment or to rescind the contract or to criminal prosecution for the bouncing check. So if there is no express stipulation reserving ownership until full payment of the price, then delivery will transmit ownership to the buyer, who can in turn transfer it to another. So in this case, the court found that there was actual delivery of the books to Santos, and Cruz acquired ownership over the books since it was delivered by Edca to Cruz. So the fact that payment was not yet made at the time of delivery was a matter between Edca and Cruz and did not impair the title acquired by Santos over the 120 books. So the court ruled here na if we interpret unlawful deprivation to embrace a case like this, na tungod raw na bayaran kay ni bounce and check, then it will result in a situation wherein a person relying on the seller's title over a movable property that is being sold would have to surrender it to another person claiming to be the original owner who had not yet been paid. So the buyer in the second sale would be left holding the bag, so to speak, and would be compelled to return the thing bought by him in good faith and without even the right to reimbursement of the amount he paid for it. So it will actually result in a chaotic situation. It will disturb property rights, ownership, title, if we interpret unlawful deprivation to include non-payment or non-payment by deceit. So, dili siya unlawful deprivation, guys. Ang katong sa first case in the Aznar, deception was employed at the time of delivery, such as there was in fact no actual delivery made. But here, deception was employed na at the time sa one. The deception was not existing at the time of delivery. Kay pag-deliver ni Edca sa books to Cruz, there was a check. So consideration in fact existed. Okay, but it turned out lang na ni-bounce lang ang check. But it will not affect the validity of the sale, of the contract of sale, nor the delivery of the property. So that concludes our discussion on chapter 8, guys. So I'll make an announcement on when we'll have our midterms. So I'll grant you this week. So next week na lang tayo mag-midterms. Ha? I'll just make the announcement in our group.